the CDS Global. Hello, everyone, and welcome to the CDS Global Cloud webinar, From Policy to Practice, Implementing China's New Cross-Border Data Regulations. I'm Mark McNeil, Director of Global Sales here at CDS. We are a public company licensed to operate in China with a 20-year history as a data center and layer 2 network supplier. We provide services such as bare metal, co-location, managed cloud services in over 90 data centers around the world. We also offer a fully meshed global private network that enables our customers to build WAN backbones, point-to-point Ethernet connections, international Ethernet private lines, SD-WAN services, and virtual private networks. In addition, global enterprises with locations, customers, or employees residing in China rely on our signature global DIA service to provide high-quality cross-border data transmission services. That will be important for today's webinar. As a member of the China Cross-Border Data Telecommunications Industry Alliance, the recent release of the new regulations by the Ministry of Industry and Information Technology is of key importance to CDS as it is to all of you joining us today. Many people have different interpretations of cybersecurity regulations in China, and they often question how to best connect their locations in China to their global networks. We at CDS help customers like this navigate those regulations and requirements every day, while enabling them to achieve seamless, dependable integration with the rest of the world. Today, we have a very special agenda planned for you. Our guest speaker is Mr. Han Wu, a partner at King & Wood Mallesons, a top international law firm. He is going to be covering the following topics: an overview of these new regulations, the impact of those regulations on international businesses, compliance strategies that you can follow to align with the new regulatory requirements, and then we'll focus on future trends in data regulation. What is coming down the road next? Mr. Wu has a long history of achievements in regulatory and compliance law. He's been named one of the 40 under 40 lawyers by Global Data Review, a next generation partner for 4 years running by the Legal 500, and a leading lawyer for the past 3 years by the Chamber's Greater China Region Guide. Please note we'll be taking questions after Mr. Wu's presentation. You may enter your questions into the chat, and then we'll get to those questions later. This webinar is being recorded, and you will be provided with a link to that recording. So without further ado, it is my pleasure to introduce Mr. Han Wu.
Thank you, Mark, for your kind introduction. And hi, this is Han from King & Wood Mallesons. Let me share my screen first so you can see my screen and slides. Okay, I suppose you can see my screen. As Mark just introduced, the purpose of this webinar is to introduce China's new cross-border data transfer rule and trying to guide you how to implement those rules in practice. But before we discuss more details about the laws and legal requirements, I think it will be helpful for us to discuss a little bit about why all different countries would like to regulate the cross-border data transfer. I mean, well, I've been asked by my clients of this question. They suppose that maybe sometimes data is too sensitive or too important to the to the company or to the government, and that's why different governments would like to regulate on this cross-border data transfer. So my understanding is like, first of all, you have to admit that the CBDT is a very popular topic in nowadays. We do have different rules in US, in EU, and of course in China. But I think the rationale of such regulation is based on two elements. The first one is that I think a lot of countries would consider data as a new kind of assets in nowadays. For example, in China, in our policy, it indicates that the data is one new kind of so-called production element. And as you can see, the data will be recognized as one kind of assets. So if you're going to transfer one kind of assets outside of China, then, well, from common sense perspective, you would say that some kind of assets being transferred should be regulated, right? Another element is that, well, a lot of companies would consider data may contain quite sensitive information. Like, for example, the press information may contain something very important regarding your privacy, your financial conditions, and even your physical conditions. So this kind of information is so important that some kind of condition should be satisfied first. And also another, like in US and EU and in India, the country would consider that some data will consider more sensitive information, like in relation to national security. Like, for example, if you transfer the military condition of China outside China, then definitely it will invite attentions from government. So in summary, that's the reason I consider different countries would like to regulate the cross-border data transfer is based on, first, data is a new kind of assets. Second, some data contains sensitive information. So in China, we do have a history of regulation of cross-border data transfer, and we do have different policies, different legal requirements. Sometimes it's too, even confusing to the market players. Cambridge Medicine, and also personally, I was involved in the different legislation of cross-border data transfer in China, and I would say that how to regulate the cross-border data transfer is quite difficult. As you can imagine, the data being transferred outside of China day to day, every day, every time, because like what we're doing now, I'm presenting a slide to you, and if you are based in EU and Mark is based in US, actually I'm transferring, data or information from China to US, right? So how to regulate such behavior? How to make sure that all this kind of data being transferred outside of China does not contain very sensitive information is extremely difficult for the regulators. So that's why after like more than 5 years discussion, finally in this year, the CAC, one of the most powerful government authority in China, issued the regulation on promoting and regulating cross-border data flow, this new regulation on cross-border data transfer. So basically, I would call that as a milestone of the China's regulation on cross-border data transfer, because we had different regulations. Sometimes the rules are even not consistent, but this regulation is trying to set up example. So from now on, we should look into this new rule. This new rule is the most updated rule. It will provide guidance on how the market players should implement different CBDT, internal mechanism to make sure of its compliance status. So in these slides, I want to give you a very, overview of this new rule. The very first topic is what kind of data is actually falling in the scope of this regulation. Sometimes my, foreign clients will have some misunderstanding of such regulation. They will say that they will have this impression that China will or has prohibited any cross-border data transfer. As you can see, that's impossible. This is not feasible, because in business, we'll have to exchange information outside of China from the business partner outside of China. So is to summarize that actually in China, only two kind of data is actually regulated by the CAC, by the government authority. One is called important data. Another one is called personal information. As for the important data, it's a unique China thing, because China, we provide a concept important data based on that if some of data is actually if the leakage of data will result in, it will jeopardize the national security, public interest. So such data will be recognized as important data. So if you're going to transfer important data outside of China, you should go straight to the so-called security assessment. The security assessment will require the market player to submit a security assessment report to the central government, which is the CAC, for review. In this security assessment, you will have to provide a very, very, very comprehensive details to convince the CAC that although the data is so important, actually it is necessary to transfer data outside of China. And most importantly, during this data transfer, all data is actually secured. Like, for example, we do have a trustful, a vendor to make sure that they adopt different technical, technical measures or management policies to ensure that the data is actually well protected. And to convince the CAC, we should present that why this vendor do have such capability and what kind of specific technical measures has been adopted. And also, you may have to mention the benchmark cases to convince CAC that this is a normal data transfer. It's no different from others. So if we, normally this kind of, security, once we submitted such security assessment to the CAC, according to my experience, generally it would take you 3 to 6 months to obtain the approval from the central government. So that's why if we're going to transfer data outside of China, the very first gesture is to make sure that you will not transfer any important data outside of China. If you do, then you have to, bear in mind that it will take you at least 3 months to complete a security assessment. So the personal information, another kind of data being regulated is personal information. Well, I guess most audience is from the EU, so you may be familiar with the data law in EU, what we call the GDPR, the General Data Regulation in Europe. So in China, we do have a similar law called Personal Information Protection Law. So generally, under GDPR, we call it personal data. In China, the Personal Information Protection Law call it personal information. Actually, the scope of personal information is similar with the personal data under GDPR. So if you transfer the personal information outside of China, you should first check whether this kind of CBDT, the cross-border transfer, would be exempted. In China, this new regulation, we provide 4 exempted scenarios. One is called the data in transit. So this is a very interesting, concept. So generally, it's like I will discuss more details after that, but just want to mention that this concept means that if this personal information is actually generated or collected outside of China, and then you transfer such data in China, and then this data go outside of China. So the China is more like a stepping stone of such the whole data flow. In that regard, this kind of cross-border data transfer will be exempted of any government approval. Another one is called the contractual necessity. So if you can convince the CAC that if this kind of personal information transfer is actually necessary for the party of this contract to implement such contract, in that regard, such cross-border data transfer will be exempted. Well, I think this kind of scenario may sound familiar to you because nowadays, if we're trying to buy, for example, the Amazon UK to buy some, if we use any e-commerce platform to buy some product outside of China, I think it will be necessary for you to transfer at least your name, your address to the e-commerce platform, so the e-commerce platform can deliver the product to your address in China. So if this is the scenario, then it should be exempted under this new regulation. The third one is called the HR management necessity. So as you can see that a lot of MNCs do have a branch in China, they will normally transfer the employee data outside of China under the reason that, well, we need to know our employee in China because they are under unified HR policies globally. And we need to, for example, we sometimes we will buy the insurance for those employees in China. And if we are trying to promote the employee in China, then we should know her or his information. So if this kind of scenario is actually, well, you do have such scenario, this kind of scenario will be exempted for the for any government approval in China. The last one is called emergency necessity. So this is quite a rare scenario, but I can provide some examples. For example, well, in the insurance scenario, if you have some incident outside of China and you're trying to get to a hospital and you do have some insurance global policy, and so you can go to, like, for example, the hospital in UK for free. But how the hospital can make sure that you do have such a policy? In that regard, they may need your personal information. Well, from China, such information will be transferred from China to UK to this hospital, and then they can ensure that the policy is essential. They can provide such services to you. So that's what we call the emergency scenario. And this kind of cross-border data transfer will be exempt of any government approval. So if we, after review our cross-border data transfer behavior, we understand that these 4 exempted scenarios does not apply, then we should, move on to see whether the company is a CIIO, the critical information infrastructure operator. This is also a unique concept in China. Normally, the MNCs will not be recognized as CIO unless you do process a large volume of important data or has been officially recognized as a CIIO by the PSB or other government authorities in China. So if you are or you have been recognized as a CIIO, well, definitely, if you transfer, theoretically speaking, if you transfer any personal information outside of China, say this, then you will have to go through the security assessment. Okay, so as you can see, that the CIIO bear definitely heavier burden of cross-border data transfer, right? So if you can exclude that you are a CIO, then you can move on to see whether your company is actually located in the so-called free trade zone. Well, as you know, in China, we have several free trade zones, like in Shanghai, in Beijing, in Hainan Province, in Tianjin, and others. So in this free trade zone, they do have a different regulation on the cross-border data transfer. We call it negative list. So generally, if you are a company located in free trade zone and you transfer personal information outside of China, what you should do is to check whether this kind of personal information or data is fall in the scope of the negative list. If it does not fall in the scope of the negative list, then all the data being transferred outside of China will be exempted. That's definitely a good news. But if you actually, all the data is fall in the scope of the negative list, then we should move on to check whether this kind of data will fall in different thresholds. Okay. So if the company is not located in the free trade zone, the next step is to check whether you transfer any sensitive personal information outside of China. So if you transfer less than 10,000 sensitive personal information outside of China, then this one, as you can see, less than 10,000 individuals sensitive personal information outside of China, you should go through the so-called SSC filing or certification process. The SEC fining, well, generally is similar with the standard contract clause under the GDPR, but in China, we should register such fining in front of provincial CAC. If you choose to not do the SEC fining, you can also obtain so-called Personal Information Protection certification from the certain institution being authorized by the CAC. So if you transfer less than 10,000 sensitive personal information, you should go through this unique process. But the very big question is like, what if I transfer like just one piece of sensitive personal information out of China? Do I still need to go through the SEC fining or certification? I'm afraid the answer is yes. You still need to go through the SEC fining and certification. Some companies will consider this kind of mechanism is absurd, is too, it's annoying, it's unreasonable. I would, partially agree on that. But after I discuss with the CAC and other government authority, I understand that the rationale of this kind of arrangement is like, first of all, the sensitive personal information is different from normal personal information. The definition of sensitive personal information is like this information is closely related to the individual's financial or physical conditions. So if this data will be leaked, during this cross-border transfer process, it possibly will jeopardize the individuals from financial or healthcare perspective. So that's why it will be better to register such cross-border transfer activities in front of provincial CAC. So that's the prevention. That's the rationale. Okay, but what if I transfer more than 10,000 individuals' sensitive personal information out of China? In that regard, then you have to go through the security assessment as we discussed before. Okay, so if you have decided which scenario the sensitive personal information has triggered, then you can move on to the so-called normal personal information. The normal personal information threshold is different from the sensitive personal information. So generally speaking, if you transfer like more than 1 million individuals' personal information out of China, then you should go through the security assessment. Okay, but if you transfer less than 1 million, but more than 100,000 individuals' normal personal information, then you should still go through the SEC fining or certification. But if you transfer less than 100,000 individuals' normal personal information out of China, you should, as you can see that you don't have to do anything because it will be exempted from any government authority. Okay, the threshold thing is very difficult to calculate, very difficult to understand. But I think the purpose of this presentation is not to guide you to how to calculate the information, but provide you a general understanding of this regulation and also and the rationale behind. So that's the roadmap or pathway of this new cross-border data transfer regulation. But as a businessman or generally as a market player, if you're not a lawyer, the first question we should ask is, what is a CBDT? What is a cross-border data transfer? The normal cross-border data transfer behavior is quite familiar to us, right? We're sending an email to a partner, and the partner is actually located outside of China, then this will be recognized as cross-border data transfer for sure. Or actually, you print out the hard copy of your financial report, which contains personal information, for example, and you take this hard copy from Beijing airport and fly it to Heathrow. In that regard, this information or this data has been transferred out of China, right? This kind of behavior will be recognized as a cross-border transfer. But what if in very extreme scenarios, it's not like I, proactively transfer the data out of China. What if I actually, our company is actually, for example, our company do have a website. The server of this website is actually located in UK. And this customer proactively log in our website and provide his or her information, personal information. Will that be recognized as a cross-border data transfer in China? Well, the Article 3 of the Personal Information Protection Law in China provided the answer to us. So very like the GDPR, we do have this similar provision. So if actually this kind of data processing activity happened outside of China, but if you're aiming to provide products or services to a leisure person within China, then this kind of data processing activity should still fall in the scope of personal information protection law in China. So in that regard, although this individual proactively provides such personal information outside of China, this kind of behavior will still be regulated in this new rule. Okay. So to understand the cross-border transfer, the general idea is that the general tool to understand the CBDT is like, first, whether this data is physically transferred outside of China. Second, even the individual proactively provides such personal information outside of China, this kind of behavior will still be regulated under the PIPR. Okay, that's the general principle of the definition of the cross-border data transfer. Another one is that because we discussed about the security assessment, SEC filing, certification, we have to deal with the Chinese government. But who should bear the burden or obligation? Well, under the PIPR or this new rule, it provides that the data handler should bear the obligation. Well, unlike the GDPR, because under GDPR, we do have different terminologies. Like, for example, under GDPR, you do have data controller and data processor, and joint processor, joint controller, right? But in China, we don't define the data controller. Instead, we define it as a data processor. And if another one is called an intrusted processor. But for your better understanding of this new rule, I will use the GDPR terminology for you to understand. So in this new rule, generally, it's the data controller will bear the obligation of different approval from government. The definition of data handler or controller is actually similar with the GDPR. As long as you can independently or jointly decide on the purpose and measures of this cross-border data transfer behavior, then you should bear the obligation to obtain approval from the government. So we discuss, another question is when we're trying to discuss about different thresholds, one important topic is the sensitive personal information, right? But in EU, we don't have this definition of sensitive personal information. Actually, under the GDPR, we do have a definition of special category of personal data. I cannot say these two definitions do have this similar scope, because according to my experience, the scope of sensitive personal information is broader than the special category of personal data under GDPR. So generally, as you can see, that if this personal information for which the leakage or illegal use can easily lead to the violation of personal dignity and also harm to the personal or property safety, in that regard, it will be regarded as a sensitive personal information. So I list a few examples for your better understanding of the scope. But as you should bear in mind that the definition of sensitive personal information is different from the definition of a special category of personal data under GDPR. Okay, and in your daily operation, as you can see, the sensitive person data can be easily transferred outside of China. I will take the human resource management scenario as one example. As you can see that I'm not sure whether the global company will collect so-called your personal ID. Because in China, your personal ID will be recognized as sensitive person information. So if you do collect such information from the employee located in China, then you transfer the sensitive person information outside of China. In addition to the human resource management scenario, in the daily business scenario, we still have a similar concept. So if you're going to sign a contract with, with your business partner in China, and if you ask the CEO or the legal representative of this business partner to provide his or her, ID, and then provide such ID in this contract, then you actually transfer the sensitive personal information outside of China. So understand the scope of sensitive personal information will be extremely important because it will lead you to, you should decide what kind of measure you should take to obtain the government approval of the cross-border data transfer. Well, another one is more technical. It's like how to calculate the specific value of personal information. Well, generally speaking, the calculation measure is quite complicated. The first one is talk about shall we evaluate the value by one piece or two pieces of personal information? Like because Mark introduced me as the partner of Cambridge Masons. Well, actually, he provides the name, but my name to you, right? And also he provides my career position to you, and then he kindly introduced me that I received different rewards from different organizations. Well, this kind of information could be recognized as personal information as well. So how many personal data has been transferred from China to US to Mark? Well, as you can see that it will be unreasonable to say that Mark transferred like 4 pieces of personal information outside China, because all this information, I would say, belong to me. This is just one individual's information. So when we try to calculate the value of the CBDT, be reminded that we only need to calculate the individual's number. We don't need to calculate how many pieces of personal information being transferred out of China. Okay. The next step is to check the value. So in this new law, in this new regulation, it says that if you're trying to calculate the data value, you should calculate the data start from the January 1st of this year, of each year, sorry. So it definitely confused many market players, because now we are in the May of 2024. How do I know that I will trigger the threshold either the security assessment or SEC finding? So in practice, the CAC would ask you to evaluate, to estimate the final value of cross-border data transfer in this year. You can use the historical data as a reference, or you can also, estimate the value based on the data being transferred outside of China for 5 months, because we are now in the May of 2024. Okay, but this is too technical. I will ignore that. Okay. So we now have I suppose that you have a general understanding of this new rule. in that regard, we'll have different examples for you to, it's not like a test, it's more like a additional introduction, so you can have some practical experience. Let's say that a company transfer 30,000 general personal information, which means non-sensitive personal information, outside of China under scenario A. Okay, for example, HR, management, and also 12,000 sensitive personal information under scenario B. So in that regard, how this company should go through which scenario, which measures, which mechanism should this company go through? As we can see in this roadmap, right? The first step to check the personal information, I suppose, is not a CIO, is not a free zone. Okay, next step is to check the number of sensitive personal information and the general personal information. Okay, I will transfer definitely more than 10,000 sensitive personal information outside of China, right? In that regard, we'll go straight to the security assessment. But what if this company would argue that, well, yes, we transfer like 12,000 sensitive personal information outside of China, but we only transfer 30,000 general personal information outside of China, because under the threshold, if we transfer less than 1 million individuals' personal information outside of China, we don't need to go through the security assessment. In practice, the rule is that if you have already triggered a security assessment, although the general personal information, the value of general personal information has not triggered a threshold, then we should still use the security assessment. Okay. Another, different concept I need to discuss about is the exemptions. I think I have already covered that, but for you to better understand scenarios, I'll make different examples. I do have different clients who will face the data transit scenario. They actually I wouldn't say global company, like for example, the subsidiary in Singapore would like to transfer their data, the personal data, to their branches in China, because China is I would say the center of their APAC business. And then the branches in China will combine all those data, China generated or Singapore generated together, and send it to, for example, Brussels. So in that regard, whether this kind of cross-border data transfer could be exempted? The answer is partially yes, because for those information generated in Singapore, actually it's generated outside of China, right? And this data will be transferred from Singapore to China and then to US. Let's suppose that during this data flow, you have not consolidate the China data and Singapore data together. You can separate that. In this regard, this kind of data will be exempted from any cross-border data transfer regulation. But for those information generated in China, this kind of exemption should not apply. Okay. Another thing I need to remind you is that a lot of companies would like to use the exemption of the performance of contract. Well, in practice, you may have to convince the provincial CAC that this kind of exemption should apply, and it will be difficult for you to convince them, because first, you should convince that the nature of this business is international, right? Like the cross-border e-commerce, like you are going to fly from China to Heathrow. You should convince that the nature of this business is international. If I don't transfer such data out of China, this business will be impossible. Okay. For example, if I'm trying to rent apartments through the Airbnb in US, I will have to provide my personal information, my bank account to the Airbnb, and then choose one apartment in New York. So the landlord would know that who is going to rent his or her apartment in the next 3 days. And also this landlord may need my contact information, just make sure that I get the keys. Well, I can try to sell it to the conventional CAC that I would say that this business is international nature, still has international nature. Because if I don't transfer such information, the business will be impossible. But what if, let's say that your global company they use different SaaS services like SAP or Salesforce provided by SAP or Salesforce or other SaaS providers. If your China company will have to use those SaaS services, but this kind of SaaS providers don't have server in China, the data will be automatically transferred from China to EU or US, where those servers be located. Would that be recognized as exempted from this scenario? The answer would be no, because this business is not international nature, does not have international nature. You cannot say that because the SaaS provider don't have server in China, the data transfer will be necessary, right? Yes, definitely they don't have server in China now, but whether do we have any vendor with the server in China provide similar business? If they do, well, I cannot use that to exempt our cross-border data transfer. Okay. Well, then the next question is, how can we, evaluate the so-called necessity principle? We're trying to say that whether those SaaS providers, whether the SaaS provider has no server in China will be sufficient to convince CAC to exempt our CBDT activity. One very important factor is so-called necessity principle. Even we don't discuss about exemption scenarios, in each of the security assessment or SEC finding or certification, we should evaluate the necessity of cross-border transfer. But how to decide the necessity of cross-border transfer? I will take the HR, the human resource management as one example. In our precedent, the CAC considered that the China subsidiary transferring the candidate information from China to US will be unnecessary. Actually, I was surprised by this conclusion. I suppose that the candidates could be our possible employee, and definitely if the global HR department would like to provide a general principle of employment within the group, it might be necessary to have all those candidates' information, right? So I'm trying to discuss with the CAC. Apparently, the CAC actually to some extent they buy in this argument. But their argument would be, I know that your company may have these global standards. You have to maintain your employment level. You do have same standards. I understand that. But if you only have like 15 employees in China, but you transfer, like for example, 50,000 candidate information outside of China, well, comparing to the employee number, the number of your candidates, the volume of candidate the volume of candidate information is too large and will be considered as an unnecessary. The reason I trying to present this example is to provide you a general principle of how to evaluate the necessity test in practice. So the CAC will evaluate necessity principle on a case-by-case basis. So you should convince them that first, how this cross-border transfer will benefit the interest of this individual. Second, compare such behavior to the other market players. And third, in your document, you should say that the consequence if the CAC prohibit such behavior, whether it will provide more burden to the business or whether it somehow jeopardize the interest of the candidate, of the individual. If you have done that, you do have the opportunity to convince the CAC. Even some scenarios has been rejected by the CAC in the past. Okay, next topic is about important data. Well, although this data security law in China only provides a very general definition of important data, but the topic of important data is very important because the nature of important data is closely related to national security and public interest. If we transfer important data outside of China without obtaining the approval from the government authority, well, our behavior will be connected to national security concerns. But in nowadays, the government has not provided a comprehensive category of important data. The only thing we have is a definition, a very rough definition. In the car business, and they do provide a few guidance on how to identify important data. But in the most of the industries, in most of the sectors, we don't have such category. So which means that the company should bear the burden of to evaluate in all those data being transferred outside of China, whether it contains any important data. But what I can disclose to you is that, well, in this year, we would expect the different industry authorities would release their draft of the category of important data. So you would have the guidance to help you to filter all the data being transferred outside of China. Well, as for the free trade zone, I will have to remind you that the free trade zone do have different cross-border data transfer rules. And well, the interesting to mention is that, well, during the legislative process, we were involved in discussion. Well, a few of the experts is actually worried about the free trade zone, because they will say that if the free trade zone would like to invite more companies to set up or to establish new company in this free trade zone to bypass the cross-border data transfer regulation, what are we gonna do? What if they provide a very narrow elective list? So the other data will be transferred out of China. They even question whether the free trade zone will have any intention, to narrow down the list of the elective list, so they can encourage or soliciting business in the free trade zone. Personally, I would say that that's possible. I mean, the whole concept of the free trade zone is to provide different or testing rules in this area, so different companies can enjoy all those special policies. So I would expect that the free trade zone, either Shanghai, Tianjin, or Beijing, will provide their unique or different new regulation on the cross-border transfer based on the elective list. Recently, Tianjin has released their elective list. But unfortunately, this new elective list does not contain what we call special rules. They still use the same thresholds to regulate the transfer of personal information. But I would expect Shanghai or Beijing will do a different thing. Maybe in those negative lists, they will use different threshold. Like, for example, they may use 1 million as the threshold of security assessment even for the sensitive personal information. For the general personal information, I think the reasonable threshold from my perspective would like 5 million or 10 million. So only if we do have such negative list, the companies will have intention to set up a company in this frame zone. But be reminded that although the elective list will open the gate, well, so-called open the gate for the cross-border transfer, it does not mean that you can, leverage those lists only by establishing a new company in that free trade zone. Again, this rule in the free trade zone only applies to the companies in this area who have been recognized as a data controller of this cross-border transfer. Okay. Well, I think that's pretty much I would like to introduce. But to wrap up, I would like to provide a few last conclusion. Although this new regulation provides a more specific guidance on how you should, comply with the CBDT rules in China, very complicated. But I don't think this will be the final rule within 5 years in China, because still the China government would like to, accumulate different experiences of, how to regulate cross-border transfer. They should understand the industry better, and different industry associations are providing, their opinions, help to polish this new rule. So I would say that the regulation on cross-border data transfer will be quite dynamic within these 5 years. But still, for the companies who are doing business in China, first, you should evaluate what kind of data being transferred out of China, and which vendor is helping you to transfer such data out of China. Because in either security assessment or asset finding, you should provide the capability of your vendor to make sure the data is actually secured during this process. And third, you may have to monitor whether there is any new legislation and whether this new legislation will provide you more obligation on cross-border data transfer. Okay, that's pretty much I would like to share today. Get back to you, Mark.
Thank you, Mr. Wu. That was fascinating. Appreciate your insights into these new regulations. We are open now to take any questions. If you would like to ask Mr. Wu a question, please enter it into the chat, and I will relay that over to you, Mr. Wu. And I guess, you know what, while we're waiting for some people to enter some questions, I actually have a question for you. This was extremely interesting information. And in summary, in your opinion, do you see this recent announcement as just a mere clarification of what the regulations and requirements that previously existed? Or do you see that this is some kind of a movement by the state government, a transformation to maybe simplify cross-border data transmissions? What is your opinion on that one?
Thanks, Mark. That's a good question. Well, I think I agree with Bloomberg's opinion, because they do have an article on that. I would say that actually China government is trying to update their regulation on cross-border data transfer. It's not like a repeat, it's an update, because they consider the old rules might be too burdensome to marketplace. But it's not like they're going to open the gate, but they're trying to update their tool to regulation on cross-border transfer.
And as you said just recently, but you see them kind of looking at the effect of this new announcement and the new requirements, and maybe tweaking those requirements as they move forward based on the reaction that they get from data transfer providers?
Yes, indeed.
Okay, great. Let's see, do we have any questions from anyone in the audience? If not, I just want to stop right here and then thank you, Mr. Wu, for that great presentation and for your insights into this recent announcement by the ministry. I think this is very helpful to everyone who attended here. And I do, speaking to our audience, I do hope that you found this useful and beneficial. As I said earlier, this has been recorded. We'll be sending you a link to that recording so you can scroll through and find information that is pertinent to you and your business situations. If anyone has any further questions after we end the webinar here, please feel free to reach out to CDS. We'd be glad to engage Mr. Wu and get answers to those questions for you, or assist you with any of your service needs in terms of data, cross-border data transmission from any of your locations in mainland China. I want to thank all of you for attending the webinar, and Mr. Wu, thank you again to you for your
Thank you.
insights and that presentation, especially the chart where you laid out the step-by-steps and the yes/no kind of things to help us kind of figure out where do we sit in this overall regulatory environment, and what is the government expecting of us specifically based on the type of data, the volume of data, and the other things that we are trying to move cross-border. I found that to be very helpful.
Thank you, Mark.
All right, everyone, thank you so much for attending. That's the end of our webinar. Look for the recording of the webinar in your email. And thank you so much. Everyone, have a great day.
Have a good day. Bye-bye.
Bye-bye.